Hello. I am Nevil Phillips. I'm a barrister at Quadrant Chambers. I practice in commercial law with a particular emphasis on shipping, energy, international trade, and insurance. Now, in these fractious modern times, brim full of international tension, I'm conscious that there is one paramount question on your lips, and that is, what is summary judgment? And that is something which, over the next few minutes, I shall try to explain. And the way I will do that is to take the topic in stages. First, a brief explanation of the concept of summary judgment. Second, how it works in practice. Third, who can seek it and when. Fourth, the procedure for seeking it. And fifth, the possible outcomes of an application. So, let's consider the concept of summary judgment. Now, here the clue is in the name. The applicant seeks the judgment of the court, but without the time and expense of a full trial. It is, in effect, a judicial shortcut, reserved mostly for those cases, A, where there is one issue which is key and which can be determined without oral evidence, or B, where, even on the most optimistic view of the evidence, there is otherwise simply no prospect of a party succeeding. Now, let's move on to how summary judgment works in practice. Summary judgment is governed by the CPR, the Civil Procedure Rules, in Rule 24. And CPR 24.3, bear with me, sets out the circumstances in which summary judgment may be granted. The court may give summary judgment against a claimant or defendant on the whole of a claim or on an individual issue if A, it considers that the party has no real prospect of succeeding on the claim, and B, there is no other compelling reason why the case or issue should be disposed of at trial. In terms of determining whether a party has no real prospect of succeeding, the court will consider whether that party has a realistic as opposed to a fanciful prospect of success. A realistic prospect requires a claim that is more than merely arguable, and in reaching its conclusion, the court must not conduct a mini-trial. However, it will take into account not only the evidence actually placed before it, but also the evidence that can reasonably be expected to be available if matters were permitted to get as far as a trial. But the court will be rigorous in its approach to this, and for this reason, in most cases where summary judgment is viable, what will be an issue is a short point of law or construction, where the relevant evidence of factual matrix is documentary in its nature and already available. Such matters are, by definition, ideal for summary judgment. And that's because if the relevant party's case is bad in law, it will, in reality, have no prospect of succeeding on the claim or successfully defending the claim against it. And if that case is bad in law, the sooner the case is determined, the better. And as regards some other reason for a trial, this will depend upon the circumstances of each case. Bear in mind that the reason must be compelling, and the court will again be rigorous with this. Ordinarily, the reason will involve the wider context of a claim and the broader impact of any summary judgment. For example, A, where the claims are within an insolvency context, where latent claims and cross-claims will remain, or B, in a claim where there will remain other issues to be determined between other parties. But a claim to set off will usually serve to defeat a summary judgment application, at least where the set off is not itself barred by a contractual provision or a rule of law, and where the set off itself requires a trial. Now, in terms of who can seek summary judgment and when, in principle, it can be sought by any party to proceedings, a claimant or a defendant, or a Part 20 claimant or defendant. And the procedure is available in any type of proceedings as against a claimant. As against a defendant, it's available in all types of proceedings except in specific possession proceedings relating to residential premises. In terms of timing, summary judgment can be sought by a defendant at any stage of proceedings after they are commenced. A claimant is more limited. They may not, without the court's permission, seek summary judgment against a defendant before the defendant has acknowledged service or filed a defence. Now, the procedure for summary judgment is governed by CPR 24.5. An application is made by an application notice under CPR 23 with a witness statement in support. The application notice must, amongst other things, A, identify concisely any point of law relied upon, B, state that the applicant believes the respondent has no real prospect of succeeding, and C, state that the applicant knows of no reason to await trial. A supporting witness statement will set out the written evidence upon which the applicant relies. The respondent will then have a right to produce its own witness statement in response, and the claimant can adduce a statement in reply. The key thing is there will be no oral evidence at any summary judgment hearing without the court's permission. And now finally we come to possible outcomes, and there are effectively three. First, the application may succeed, and the court will give final judgment with costs accordingly. Second, the application may fail and be dismissed, in which case the claim will proceed to trial in the ordinary way, and the unsuccessful applicant may be ordered to pay the costs of the failed application. Third, the court may dismiss the application, but on the basis that the respondent's position is marginal, where it's unlikely to succeed at trial. And in this event, the court may make a conditional order, requiring the respondent, if it's the defendant, to pay into court the sum in dispute, or if it's the claimant, to provide security for costs. And if the position is marginal in this way and to this degree, the court will only decline to impose one of these conditions if it's persuaded on evidence that it would be impossible for the relevant party to comply. And that, in my judgment and in summary, is summary judgment. Thank you for listening.